Secularism, such a buzzword. Do you really know what Indian secularism is?
राम मंदिर की प्राण प्रतिष्ठा सेरेमनी के बाद ज़्यादातर जगहों पर भगवा फ्लैग्स ही नजर आए। रिपब्लिक डे पर भी कई लोगों ने सोशल मीडिया पर शेयर किया कि उन्हें इंडिया के फ्लैग के बजाय ज़्यादातर जगहों पर भगवा झंडे दिखे। पॉलिटिकल डिस्कोर्स में वैसे अब सेक्युलरिज्म शब्द एक रेड फ्लैग बन चुका है। ज़्यादातर लोग इसे लेफ्ट लिबरल एजेंडा, एंटी नेशनल या फिर एंटी हिंदू कहकर खारिज कर देते हैं। लेकिन भगवा झंडों और राम मंदिर के बीच सेक्युलरिज्म को कैसे समझा जाए?
SR Bommai versus Union of India इसमें एक important case है. The research that I have collected is based on a paper by Soumya Saxena, a postdoc at University of Cambridge's Faculty of History. In 1993, the national president of the Janata Party, that is SR Bommai, filed a case urging the application of emergency provisions, or as we all know, the President's Rule, that is the Article 356 of the Constitution, in riot-affected states post the Babri Masjid demolition. This article empowers the central government to assume control over the state's administration. The imposition of Article 356 after the mosque's demolition was justified on the grounds of a threat to secularism and the public unrest that it triggered. Due to the ambiguity surrounding secularism's definition in public discourse, the courts not only interpreted but also reflected on secularism. They enacted it in response to the acute communal tensions alongside addressing federalism concerns. कुछ ऐसा ही अभी भी हो रहा है, क्योंकि हम आए दिन सेक्युलरिज्म की बात करते हैं, एक दूसरे को चीज़ें बोलते हैं, लेकिन क्या हम सही में समझते हैं कि सेक्युलरिज्म का क्या कॉन्टेक्स्ट है? आप सभी ने देखा होगा कि माईगव के ट्विटर पेज पे प्रियम्बल का जो पुराना एक वर्जन था जिसमें सेक्युलरिज्म और सोशलिज्म शब्द नहीं था, वो शेयर किया गया रिपब्लिक डे पे। इसको थोड़ा और बारीकी से हमें देखना चाहिए। Renowned scholar Rajiv Bhargav highlights the uniqueness of Indian secularism, emphasizing a contextual doctrine advocating a principled distance from all religions and equal respect for all religions. यानी एक contextual version है इंडियन सेक्युलरिज्म का। आप हर तरह से देखते हैं कि स्टेट एक प्रिंसिपल डिस्टेंस रखे हर एक रिलीजन से और सबके लिए एक इक्वल सेंस ऑफ रिस्पेक्ट रखे। Now this extends beyond mere tolerance, enabling the state to establish a flexible relationship with religion based on temporal and circumstantial considerations. In the 1970 parliamentary debates, जब सेक्युलरिज्म को प्रियम्बल में डालने की बात हो रही थी, डिबेट चल रही थी, Jambuwant Rao Dhote from the forward bloc argued that the term secular lacks an exact Hindi translation. हिंदी का जो translation है वो ज़्यादातर इस तरह का होता है that it suggests religiousness, which is actually an unfair interpretation of Indian secularism. राजीव भार्गव का मानना है कि this insertion of the term secularism in the Indian constitution sparked multiple challenges, allowing various factions to appropriate and distort the label of secularism. The cultural evolution of the term, he argues, is a collective effort involving courts, groups and governments. Now let's talk about the role of the Supreme Court in the implementation of secularism. The Supreme Court provided guidance in the SR Bommai case basically and asserted, and this is a quote, "In matters of state, religion has no place. No political party can simultaneously be a religious party." The judgment upheld the imposition of President's Rule at the time in Himachal Pradesh, Madhya Pradesh and Rajasthan. Beyond the deteriorating law and order situation, the court considered that the chief ministers of these states were members or sympathizers of the RSS, the organization that was instrumental in the demolition of Babri Masjid. The court emphasized that it is neither possible nor realistic to disassociate the governments of Madhya Pradesh, Rajasthan and Himachal Pradesh from the acts and deeds of their party. यानी 1993 में सुप्रीम कोर्ट का मानना था कि सेक्युलरिज्म के प्रिंसिपल्स की वजह से कोई भी पॉलिटिकल पार्टी रिलीजियस पार्टी नहीं हो सकती है, क्योंकि एमपी, राजस्थान और हिमाचल के चीफ मिनिस्टर्स आरएसएस के मेंबर्स या सिंपथाइजर्स थे। उन्होंने इस प्रिंसिपल का एक तरह से उल्लंघन किया और मस्जिद गिराने में और उसके बाद हुए कम्युनल वायलेंस के लिए उन्हें कहीं ना कहीं कोर्ट रिस्पॉन्सिबल मानता है और तभी सेंट्रल गवर्नमेंट का ओवरटेक उनके एडमिनिस्ट्रेशन पर उन्होंने अपहेल्ड किया। So what happened after the प्राण प्रतिष्ठा मूवमेंट at the राम टेम्पल?
बीते रविवार को मध्य प्रदेश के झाबुआ में कुछ लोग जय श्री राम के नारे लगाते हुए एक चर्च पर चढ़ गए और चर्च के शीर्ष पर उन्होंने भगवा झंडा लहरा दिया। सोशल मीडिया पर वायरल हुए एक वीडियो में कुछ लोगों को इमारत पर चढ़ते और ईसाई क्रॉस पर एक झंडा लगाते हुए देखा जा सकता है। भगवा झंडे पर अयोध्या राम मंदिर की तस्वीर और जय श्री राम लिखा है।
These incidents following the Ram Mandir ceremony evoke echoes of the aftermath of the Babri Masjid demolition. The Supreme Court at that time had significant observations on the escalating communal tensions and emphasized the role of political leaders and parties in inciting hate. The court clarified that the mosque's demolition was not a sudden, unprecedented event, but the culmination of a sustained campaign. The BJP and its allied organizations consistently expressed a desire to construct a Ram temple in place of the mosque, as evident in the 1993 BJP manifesto that condoned the mosque's demolition. The court raised serious questions about the state administration's willingness to protect the minorities, particularly given the RSS's complicity in the demolition and ensuing riots. Therefore, the court's decision was a response to what it perceived as a genuine threat to law and order by the public, incited to form riotous communities through a sustained campaign by the BJP. How did the courts give legitimacy to the mosque and the temple narrative? What really is the legality of demolition? A lot can be understood through the Babri Masjid and the Ram Janmabhoomi. Most popular discourse today is stuck on a whataboutery of which regime did what they want to do, etc., etc. Let's backtrack and look at what happened then. Once the threat to law and order was announced, the Narasimha Rao government took a step. Hurriedly through an ordinance, the Ayodhya Act of 1993 was brought in. Under this act, 67.7 acres of land within Ayodhya, that included 2.77 acres of the Babri Masjid, was acquired by the central government. The Ayodhya Act was subsequently challenged in court in the Ismail Faruqi case, and its validity was upheld barring one section, that is section 49. Here the bench respectfully declined to respond to the presidential reference, citing that they wanted to determine whether a structure or indeed a Hindu structure or a Ram temple existed underneath the mosque. The court basically meant that the fact that a Ram temple or Hindu structure existed prior to the mosque had to be established by archaeologists and not the court. लेकिन इसका मतलब ये नहीं था कि कोर्ट इसको चेक करना चाहता था. Court's decision to uphold the validity of the Ayodhya Act meant that the demolished mosque would not simply be re-erected now. The court's objects and reasons made it clear that on the disputed land, now a mosque, a temple and much else would be accommodated. The court observed, as it is necessary to maintain communal harmony and the spirit of common brotherhood amongst the people of India, it was considered necessary to acquire the site of the disputed structure and suitable adjacent land for setting up a complex which could be developed in a planned manner wherein a Ram temple, a mosque, amenities for pilgrims, a library, a museum and other suitable facilities can be set up.
What is so significant about the Ismail Faruqi judgment?
The court first gave legitimacy to the claims for different religious institutions to be on the ground. Second, the judgment of Ismail Faruqi versus Union of India had started giving way to the argument that the demolition was the work of a few miscreants, overlooking the BJP's manifesto and the role of the RSS as it had determined and placed in the SR Bommai case. The judgment also cited the existence of religions other than Hinduism in India as an example of the tolerance enshrined in Hinduism, which essentially is responsible for enabling Islam, Christianity, Judaism, Buddhism, Jainism and Sikhism to exist in a country. The use of words like shelter and support to describe the accommodation of non-Hindu religions in India betrayed the status accorded to other religions in the perception of the court. So once again, to repeat, while the judgment steered clear of the presidential reference, the Faruqi judgment once again confirmed that the mosque would not be restored and passed the responsibility of managing the disputed area to the government. Simultaneously, the court read down a section of the Ayodhya Act that prevented further litigation on the matter. Court thus continued to remain a central part of the dispute, even as political parties promised to build a temple or rebuild a mosque or protect the minorities in their respective manifestos. The court granted legitimacy. Saxena argues that the judgment cited the existence of religions other than Hinduism in India as an example of the tolerance enshrined in Hinduism, and that's exactly where the court's interpretation starts giving way to a lot of communal disruption.
Is the Ram Janmabhoomi and the Babri Masjid the first of its kind in India?
Everyone is closely following the developments of the Gyan Vapi today. Most popular narrative associates the similarity of the mosque over the temple of all these instances to the Babri Masjid. However, in the 1940s, a similar dispute arose called the Shahid Ganj case. The principle of adverse possession meant that if one's property is taken by another and no suit is filed within 12 years, then the possession would be lost under the Indian Limitation Act of 1908. In 1940, this had been applied in the Shahid Ganj case, a similar dispute between a mosque and a gurdwara, and the land was restored to the Sikhs on the ground that the building had been used like a gurdwara for more than 12 years. The Faruqi judgment held that given the mosque had also been in use since the 1950s, it could be acquired now by the state as any other religious place could be. However, it infamously made the unnecessary observation that a mosque is not an essential part of the practice of the religion of Islam, and namaz by Muslims can be offered anywhere, even in the open space. Accordingly, its acquisition is not prohibited by the provisions in the Constitution of India. Now, this was the Supreme Court's observation in the Ismail Faruqi case. Hindutva and elections. Can the BJP run its electoral campaigns on Hindutva? What does the Supreme Court say? Most supporters of the Ram Mandir are also not blind to the monopolistic usage of the Mandir by the BJP for electoral gains this year. But is this even legal? Clearly, the Supreme Court established that a political party cannot be a religious party. So how does this work during elections? Let's give an example. Yashwant Prabhu, a candidate of the Shiv Sena, won a by-election in 1987. In the course of his campaign, Bal Thackeray, the founder and leader of the party, declared in a series of speeches that they campaigned solely for the votes of Hindus. He has been quoted to be saying, "We are fighting this election for the protection of Hinduism. Therefore, we do not care for the votes of the Muslims. This country belongs to Hindus and will remain so. They should bear in mind that this country is of Hindus and shall remain to be of Hindus forever." Yashwant Prabhu's election was challenged in the Bombay High Court. The Bombay High Court declared the election of Prabhu as invalid under Section 123 on the basis that the use of religion was a corrupt practice in elections. Prabhu's subsequent appeal to the Supreme Court was also dismissed. But the Supreme Court expressed distress at the nature of the speeches being given and condemned the derogatory terms attributed to religious minorities. However, the court in its observations accepted the use of the term Hindutva as one that did not necessarily refer to a religion but to a way of life. The court, even as it dismissed Prabhu's appeal, concluded that the use of the term alone did not amount to invocation of religious identity for votes. Bound by secular commitments that had been painstakingly established in the Bomai case, Hinduism was separated from Hindutva in order for it to remain a legitimate campaign without attracting penalties under the Section 123 of the Representation of Peoples Act. The court entered into the definition of Hindutva and Hinduism when the requirement was only of ascertaining the corrupt practice of using religion in a campaign. Thus, the court, deeming Hindutva a secular campaign strategy, was crucial for the political and electoral success of the Hindu nationalist movement. The court observed, and this is a quotation, "It may well be that these words are used in a speech to promote secularism or to emphasize the way of life of the Indian people and the Indian culture or to criticize the policy of any political party as discriminatory or intolerant. This then set a precedent. However, this was not the first time, because in the Manohar Joshi case of 1967, Joshi in his speeches had repeatedly expressed a desire for a nation constituted by and for Hindus. However, the Supreme Court took a rather sympathetic tone towards Joshi's use of the term Hindu state. The court said, and I quote, "In our opinion, a mere statement that first a Hindu state will be established in Maharashtra is by itself not an appeal for votes on the ground of his religion, but the expression at best of such a hope. However despicable be such a statement, it cannot be said to amount to an appeal for votes on the ground of his religion." The Supreme Court concluded that the election was valid. The observation of the court in effect embraced Savarkar's theory of Hindu as a subset of Hindutva. V.D. Savarkar described the concept of Hindutva as not a mere word but a history, of which Hinduism is merely a derivative form. Once the courts disassociated Hindutva from religion, it could be treated like any other political ploy which could be subject to criticism without the guilt of blasphemy, real or metaphorical. So, the real win for the Hindutva ideologues was not merely that their philosophy was deemed by the court as synonymous with Indianization or Indian culture, but rather that it was deemed a secular ideology. Saxena has then argued that the distance between the state and religion was not always principled, and the way of life interpretation of religion was applied more favorably to Hindus than to other minorities, as seen in the case of the ban on cow slaughter. Now, when we're talking about secularism and going back to what we've already discussed, now in the S.R. Bommai case, the interpretation of secularism and the role of the BJP and the RSS and the demolition of the Babri Masjid was very different, and the way that interpretation changes is very, very critical. In the Constituent Assembly debates, there was no real consensus on what secularism meant, except that as Pakistan moved towards unity as a theocratic state, secular India also sought a unitary identity. If the state was to be defined by what it opposed, a secular status for India at the time of independence was the negation of the theocracy in Pakistan, thus escaping the need to define secularism or pluralism. And this was reiterated over time in both legislative debates and judicial pronouncements. However, with the court's acceptance of a hope for Hindu state as legitimate, Hindutva being different from Hinduism and that being a legitimate electoral ploy, the doctrine of Indian secularism no longer remained a negation of the theocracy. Therefore, Indian secularism has actually not really been defined from the Constituent Assembly to the Supreme Court. The S.R. Bommai case was very, very significant, but however, other interpretations of electoral speeches and electoral ploys, what can be used and what cannot be used, the differentiation between Hindutva and Hinduism for elections is something that has really changed the interpretation of secularism. After all, in its essence, of course, secularism for any country means the separation of religion and state. However, that line is getting blurred in India, and the role of the courts is quite significant for this.